Hello everyone, my name is Sanmati Isram. I'll be discussing about state under Indian Constitution. First, I'll be going forward with the introduction. Then I'll be explaining about state under Article 12. Then the interpretation of the term state, case laws, then the conclusion. Before I go forward with the Article 12, I'll be defining and distinguishing fundamental rights and constitutional rights. Fundamental rights are conferred under Part 3 of Indian Constitution to every citizen. Constitutional rights are spread throughout the Indian Constitution. Fundamental rights protect individuals' freedom and liberty. Constitutional rights includes fundamental rights, directive principles of state policy, and other rights. Fundamental rights are justiciable. Constitutional rights are not justiciable. In the sense, if there is violation of fundamental rights, one could approach court. That is not available in case of constitutional right. There are reasonable restrictions imposed on fundamental rights. For example, Article 12 has subjected restriction of procedure established by law. Constitutional right is also subjected to restriction. For example, right to property under Article 300A can be snatched away by authority of law through ordinary amendment. If I have to describe further about constitutional rights, they are classified as civil rights, political rights, economic rights, and social rights. Civil rights are the rights, powers, and immunities that are conferred on citizens by virtue of them being citizens. In Husainara Cartoon and others versus Home Secretary State of Bihar, it was held that right to speedy trial is a part of Article 21. It was held that the state is under a constitutional mandate to ensure speedy trial. Example of civil right is the right to vote. Political rights are the rights by which citizens of a country participate in the political agenda of a country, including management of government. Example of political rights are right to criticize the government, right to contest in elections. Economic rights. These rights are guaranteed under Indian Constitution to ensure economic security of every Indian citizen. We should strive to make India a welfare state. Example of economic rights are the right to work, right to good working environment, right to food, which are part of Article 21 of Indian Constitution under right to life. Social rights. Social rights are those that are important for the fulfillment of societal demands and promotion of social inclusivity and solidarity. Example of social rights are right to healthcare services, right to free legal aid, right to employment. Fundamental rights are categorized into six classes: right to equality, right to freedom, right against exploitation, right to freedom of religion, cultural and educational rights. Article 29 states that every residing citizen who has a distinctive language, script, or culture shall have a right to conserve the same. Article 30 lays down that the religious minorities have the right to establish and administer educational institutions. Last but not the least, right to constitutional remedies. If a person's fundamental rights are violated, he could approach the court via writs. Those writs are writ of habeas corpus, writ of mandamus, writ of certiorari, writ of prohibition, writ of quo warranto. Before I go forward with the definition of state, let me first read out what Article 12 states about. The state includes the government and Parliament of India, and government and legislature of each states, and local or other authorities within the territory of India or under the control of the government of India. Let me break down the definition of state. It includes government and Parliament of India, that is the executive and legislature of this union. Government and legislature of each state, that is the executive and legislature of various states of India. Local authority or authorities within the territories of India or under the control of Government of India. As stated in the previous slide, the term state includes government and Parliament of India. This further includes governmental departments or the institutions which are a product of governmental departments like the income tax department. Then it includes the president in his official capacity. It also includes state legislatures and executive, and bodies like municipalities and panchayats are a part of local authorities. it will not be a part of this particular slide. It also includes union territories. Local authorities, local or other authorities. So this expression has been defined in section 3 subclause 31 of General Clauses Act 1897 as a municipal committee, district board, body of commissioner or other authorities legally entrusted or entrusted by government within the control or management of a municipal or local fund. The expression local authority usually refers to authorities such as municipalities, district boards, panchayats, etc. Any functioning authority which is owned by state and controlled by the state and managed by the state and is carrying out a public function will be a part of local authority. In Union of India versus R.C. Jain, the Supreme Court laid down tests to determine which are the bodies which are conferred the status of local authority. First, the body should have a separate legal existence. Then it should have a function that is in a defined area. It should have the power to raise funds on its own. Then it should enjoy autonomy. Then it should be entrusted by the statute with functions which are usually entrusted to municipalities. Then it should have the power to raise funds for its furtherance and fulfillment of objectives by levying taxes, rates, charges, or fees. In Shamdasani versus Central Bank of India, some shares of the petitioner were sold by the Central Bank of India to recover the debt owned by the petitioner. This was challenged on the ground of being violative of Article 19 and 31. It was held that private bank is not a part of state. In University of Madras versus Chantabai, the Madras High Court evolved the principle of justum generis, meaning that like nature should be treated alike. Further, it also stated that it cannot include persons natural or juristic, for example, unaided institutions. In Ujjambai versus State of UP, the court rejected the above restrictive narrow scope of justum generis rule and held that it could not be resorted to in interpreting other authorities. In Rajasthan Electricity Board versus Mohanlal, the Supreme Court held that other authorities would include all the authorities created by constitution or statute on whom powers are conferred by law. Such authorities need not be engaged in performing government or sovereign functions. If there is an IT department, its sovereign function will be to levy taxes. In case of the same example, if we take non-sovereign functions, the income tax department can educate the general public about the various tax slabs available. That will be its non-sovereign function. The court emphasized that it is immaterial that the power conferred on the body is of a commercial nature or not. There is a doctrine called as doctrine of instrumentality of a state. So to determine that, there should be share capital and financial assistance. That is, if whole of the share capital of the corporation is owned by the central or state governments, then it will show that the corporation is an instrumentality of a state. In Sukhdev Singh versus Bhagat Ram, the court observed that it is not necessary for the state to provide direct financial aid to corporation. The state may provide tax exemptions or other forms of indirect financial assistance to the corporation. Indirect financial aid can also be a relevant factor while determining whether a corporation is an instrumentality of a state or not. The next category or a criteria that has to be evaluated will be that it should be under state control. If central or state governments exercise pervasive control over the entity, then it can be included under the definition of state. Then there should be monopoly, that is certain corporates should enjoy monopoly in respective of their market because the state empowers the corporations such a power. Thus, if an entity enjoys monopoly status due to restrictions imposed by the law, then such entity is likely to be considered as an agency or instrumentality of a state. Then the next criteria will be the functions. The nature of the functions conferred by the corporation is another relevant factor. It is if the corporation empowers or discharges functions which are largely of a public nature, then such a corporation will be considered as instrumentality of a state. Whether a body falls under state or not. In R.D. Shetty versus Airport Authority of India, Justice P.N. Bhagwati gave 5 points. That is a test to determine whether a body is an agency or instrumentality of a state, and it goes as follows. Financial resources of a state, where the state is the chief funding source. Deep and pervasive control of the state. The functional character being governmental in nature, meaning thereby that its functions have public importance or are of a public character. A department of government conferred to a corporation enjoys monopoly status which state conferred or is protected by it. This is, however, elucidated with the statement that the statement is only illustrative and not conclusive in nature and is to be approached with great caution and care. Whether state includes judiciary or not. In Rupa Ashok Hura versus Ashok Hura, the Supreme Court reaffirmed and ruled that no judicial proceeding could be said to be violative of fundamental rights, and it is a settled position of law that superior courts of justice did not fall under the ambit of state or other authorities under Article 12. Some of the case laws in Rajasthan Electricity Board versus Mohan Lal and others, it was questioned whether Electricity Board comes under the definition of state or not, that to other authorities. It was held that Electricity Board is an instrumentality of a state and hence fell under the definition of state. In Zee Films versus Union of India, where the Board of Cricket Control of Cricket in India, that is the BCCI, that is registered under the Tamil Nadu Societies Registration Act in 1975 is a state or not. The government neither owns a substantial part of BCCI nor does it exercise any deep or pervasive control over its management and affairs. BCCI was established by not a statute and thus it does not function as an instrumentality of a state. In Shiny George Ambath versus Union of India, Shiny George Ambath was the CEO of IIM Kozhikode. It was held that IIM could not be a part of instrumentality of a state as the central government does not exercise pervasive control over the internal management, and those financial grants could not be called as substantial financial assistance, and the majority of the expenses were borne by the institution. In conclusion, the broad definition ensures that any action taken by the government or its agencies can be questioned in the court of law. There is a debate whether BCCI should be included within the ambit of PEL or not. In 275th report, the Law Commission of India asked the government to treat BCCI as an agency of state under Article 12. In Sanjaya Bahel versus Union of India and others, the case dealt with the issue of immunity enjoyed by United Nations organizations under United Nations Act 1947. The Delhi High Court in May 2019 declared that UN is not a state under the definition of Article 12 of Indian Constitution.